You would have to make a note of this point, because I think this point was also made by another counsel, whether the Urdu version or the English version is the translation of the other, or are they not written as translations, but simply another officer writing the same report at another occasion. That's what I thought it was, but you have to tell me whether it is a translation.
My view is a bit different on that, but I'll come to that when I continue listening with the argument.
No, your point is that they are translations.
Not translations, but the things that were not there in the first report just to cover up certain lacunas in that second report, because even the nominated persons in the second report.
So which was the first one? Which one was the first
English
one?
one was the first one.
Chief, please.
So the English one is a report based on the report of the field staff. Field staff is principally the employees of each department, whereas the one in Urdu is a source report. There is no mention of any field staff with respect to that.
But you said English is the first one.
English is the first one,
Which mentioned field report.
which
Field
mentions the
sources.
field staff.
Right. Mentioned field staff. But Urdu didn't.
Urdu did that. The Urdu simply says it to be a source report. The Urdu simply says it to be a source report. There is no mention of field staff. Because field staff is basically the staff of the agency that is making a report. Secondly, my lord, the English report, when it is read, it talks about, in para B, usually the initiator of controversial remarks is called to some girl and negotiated for settlement. However, this very clear knowledge of settlement is not there in the report that has been published in Urdu by the special branch.
Okay.
Thirdly, my lord, there is an important element, if I may take a certain liberty by the permission of this honorable court. In the English report, they state it, I'll read it out to your kind convenience, that this is some foreign agenda upon which these people are working. And once such a matter came before the court in these proceedings, taking some leverage, I'll state that your lordship was of the opinion that a foreign agenda का जिक्र आता है पाकिस्तान के perspective. I couldn't agree more. तो प्रिंसिपली यही नजर आता है कि वो लोग सच ही बोल रहे हैं जिन पर फॉरेन एजेंडा का एग्रीमेंट जो है वो किया जाता है. So it is basically the respondents who have been alleged to be working on some foreign agenda. However, this foreign agenda is not present in the report that was prepared by the special branch in Urdu, and thereafter recommendations of both the reports are different. I'll read out the recommendations. The one in English: FIA may be directed to launch a thorough probe to take out discrete activities of the gang. Those found involved in illegal activities and anti-social activities may be proceeded against under the relevant laws. The recommendation number 2, FIA may also conduct forensic of mobile phones of complainants of blasphemy incidents committed on cyberspace to determine the actual source of crime. Now, Lord, if your lordship may come to the report, the comments that have been filed by the Interior Ministry, if they are before your lordship. Starting off from error number 2 of these comments, that a typed letter of the application without signature of some impression of the applicant person rendering request for constitution of judicial inquiry on the special branch report Punjab Police along with list of applicants CNA number addressed to the Ministry of Interior was received. The same was forwarded to the FIA for further and necessary action as per rules of law. that in reply, the FIA stated that the matter has been thoroughly examined with the coordination of special branch and found that the information does not show any contact of the relation of the enmity among complainants and the accused persons. Moreover, there is no corroborative incriminating evidence that can prove the allegations in the said source report regarding trapping, extortion of money from the accused persons or any of the relatives, nor any evidence provided by the families of the alleged accused arrested in blasphemy cases. Fourth, FIA has further stated that the inquiry investigations are based on independent complaints received and are scrutinized through legal and technical protocols. FIA, being relevant law enforcement agency, deals with different nature of cyber crimes offences, including hate speech, section 11 of PICA 2016, and registered cases on account of blasphemy through online social media.
Where is the FIA's reply with this?
Comments on behalf of the FIA are FIA was included as respondent number 4. They have replied to the writ petition, in essence. Parawise comments of the writ petition are, there are 3 judicial directors. Let's start from here.
So, why have they not attached the reply of FIA instead of simply summarizing it? Who's the author of that reply by FIA?
On behalf of the
Dekhi counsel, please don't prolong this case. You could have simply said, which has been heard by this court on several occasions, that respondent number 3 and the FIA have taken a categorical stance that there is no evidence before them of such complicity.
No.
That's all.
I'm sorry for the lengthy arguments. So both the recommendations that were made by the report of the special branch in the English report, the first report, both of those recommendations have already been fulfilled. They stand fulfilled. For the reason they recommended that the matter may kindly be sent to FIA for a thorough probe. Now, both the FIA and the Ministry of Interior in their comments have stated that the matter was sent for probe to the FIA and they have probed and they have not found anything as of that. So, principally, this report cannot be, on this report has already been exhausted and this report, the inquiry conducted by the Ministry of Interior and FIA have achieved finality. However, the recommendations made in the Urdu reports are different. Wherein, because I earlier submitted before this court that things which were left in the first report as of a lacuna, that were basically fulfilled in the second report. So in the second report, they came up with the terminology of an independent commission to be formed under the Commission of Inquiry Act. Thereafter, my lord, the total cases.
What was the timing difference between the Urdu and the English report?
My lord?
What was the timing difference? What were the dates of the two reports?
My lord, the dates concerned the dates, the copy that I have, they do not have the dates of both the reports. Copy of the petition that I have, they do not have the reports, the dates.
Now, let's just make corresponding letters and internal correspondence in the dates mentioned.
वो आप मुझे बता दीजिएगा।
Now, my lord, time down to para C of the first report, the total cases that were seen to be of some matter were 21 in nature.
Counsel, Counsel, I have had, my patience is running out because all the counsels keep going into the merit of the question before me, whether or not there is sufficient evidence present of FIA's involvement in the so-called, or the other person's involvement in the so-called, or what is claimed as the gang. This is not, I have mentioned it a zillion times, this is not the question before me. Either a criminal court will look into it based on the specific FIR, or if this petition is allowed, then the commission is supposed to look into it whether there is sufficient evidence for that. Why your first argument was, I take it on board and I will rule on that the matter brought before the court for a direction to constitute a commission is not a definite matter. And you've highlighted a couple of points that the documents that have been presented to the court do not contain a sufficiently definite question to be probed. That is your argument. But then you sort of digress by going to saying that FIA is saying there is no evidence at all. That is a separate question. So let's go on to your next point.
So let I move on to my next point. My lord, my next point would be with respect to entrapment. And now, my lord, as insofar as the question of entrapment is concerned, because that is where we were on the last day of hearing when this matter was.
That is again a question, learned counsel, that there is no entrapment or there is entrapment. Again, that is not a question for me to decide.
However, because the report of the NCHR has briefly discussed upon it, so in light of that report, if your lordship only allows, then I will assist. Because the entrapment that has been given before this court, of the documents that have been presented, that are with respect to objective entrapment, not subjective, which is therefore a commission of offence. Objective entrapment is with respect to apprehension of the accused.
Okay, I'll hear you on this point. Go ahead.
Lord, I'll move on to the next point here.
No, on entrapment.
Lord, so insofar as entrapment is concerned, there are two types of entrapment. One is subjective, which is made for the commission of an offence. The second is objective, which is there for the apprehension of the accused. In this perspective, I draw your lordship's attention to the report of the NCHR, whose respondent number 6, and if your lordship may kindly consider the reply of para number 6 in this regard.
NCHR's reply?
Reply. Para number 6, I'll read out from the findings of from 93 prisoners interviewed in death. We first is contact by using a girl, that then this is also an objective entrapment. This is not for the commission of offence, rather it is for the apprehension of an accused. Because
I'm not clear, counsel. What do you exactly mean by that? First of all, please explain the difference between the two.
one,
ये NCHR की रिपोर्ट दीजिएगा जरा.
one entrapment is subjective in nature. I'll exemplify that if I entrap some person and I then make him do some commission of offence, that is basically a subjective entrapment.
Okay.
And the other is objective. If I see someone doing a commission of offence and I trap him so that he be apprehended by the law enforcement agencies, by the LBAs.
I do not know where this distinction is coming from and what bearing does it have in
Lord, I did find
what moorings it have in the law. दिखाइए मुझे.
Lord, they are not recognized per se in the Pakistani law.
Can I ask NCHR's counsel to help me with this? Is it a concept you're borrowing from the US law?
Your Honor, this distinction has not been made in the NCHR.
It is not in the NCHR report. I am making this distinction for the purpose of assisting this court.
Counsel, then I am, but you refer to paragraph 6 of their reply.
For the reason that the reply of the NCHR has given some specific details, I am drawing the attention of this honorable court towards the fact.
Reply of the NCHR has given no details whatsoever.
Your Honor, the page of the
तो number 2 का है, number 6 का किधर है?
Page number 7 of the paragraph. Basically, some statistics that we agree with you that is there in the NCHR report, present report. One of those statistics is that of the 93 individuals who were interviewed at length by staff of the NCHR at different jails all over Pakistan, 83 of them, which is 89% of the 93 individuals, were contacted by a girl. So I think Unit Counsel is referring to the fact that NCHR is referring to some distinctive mode of entrapment, which is basically, my contention is that that is not true. Along different diverse areas, geographical areas, for example, Karachi, Multan, or different